Hi Papua New Guineans. Listen to the full story of William Duma and the Manu Manu land scandal. The Manu Manu land scandal rocked the nation back in 2017. In response to the public outcry, an administrative inquiry was launched at a cost of 2 million kina to taxpayers. While the inquiry report was tabled in Parliament on April 13, 2018, the public were denied copies of a report which they had paid for. Then, a month ago, it was leaked online. PNGi is committed to documenting the report's key findings. Today we begin with William Duma and portion 406. The facts are straightforward enough, and by any stretch shocking given the police commissioner's decision that there is nothing to see here. There is. Approximately 46.5 million kina has been taken from the PNGi Defense Force through a crooked land deal, denying long-suffering soldiers serving this country much-needed financial resources. The rank and file of our armed services should be outraged by what this investigation discloses. On July 30th, 2015, estate lease over portion 406 was acquired by Kirkaram Estates Limited, paying no more than application fees of 650 kina. Portion 406 is an 847.25 hectare plot of land 75 kilometers west of Port Moresby along the Hiratano Highway. It was valued on July 30th, 2015 at 99 kina per hectare or 84,420 kina in total. At the time, Lancre Naval Base in Port Moresby was relocating to portions 422 and 423 that were adjacent to portion 406. No mention is made of portion 406 in the relevant Defense Council decision made on February 27, 2015. Only later, on October 15, 2015, is portion 406 identified for the relocation exercise in a letter from Dr. Fabian Pak, the Defense Minister. On November 3, 2015, the Valuer General's Office conducts a valuation of portion 406. Its value evidently leapt 555 times to 55,000 kina per hectare or 46.6 million kina in total. Let that sink in. In the space of 3 months, according to the government valuers, this rural landholding increased 555 times in value. The inquiry deemed this to be grossly excessive and explicit evidence of wrongdoing. Put simply, November 3, 2015 was a day when Kirkaram Estates' sole shareholder learnt that their humble 84,420 kina asset, acquired for 650 kina, was now worth 46.6 million kina. But who was the mysterious owner of this land whose investment just rose 555 times in value over 3 months? Kirkaram Estates' office address and postal address were the home and postal address of William Duma, who was Minister for Transport up until January 11, 2016, when he was made Minister for State Enterprises. Duma intimated to the inquiry that a rogue element used these addresses without his knowledge. Kirkaram's sole shareholder and director, Christopher Polos, was said to be Duma's brother-in-law. Duma confirmed Polos was his brother-in-law, then realized he got matters wrong. Christopher Polos was in fact an individual living on Bougainville. His brother-in-law, Duma finally remembered, was in fact K-Boy Polos. Easy mistake to make. That's okay. Surely a close examination of the land's records would tell the public whether there was any foul play. All of the records have gone missing from the lands department. However, it was learned that a contract of sale was reached on December 11, 2015. The independent state of Papua New Guinea would pay 46.6 million kina on behalf of the PNGDF. On October 14, 2016, State Enterprise, Cumul Consolidated Holdings formally agreed to pay the vastly inflated sum on behalf of the PNGDF in return for PNGDF land at Fairfax Harbor. There was one problem with the deal struck. Kirkaram Estates failed to affix its corporate seal to the Memorandum of Agreement. Strangely, Cumul's managing director did not alert Christopher Polos, Kirkaram Estates' sole shareholder and director. Instead, he emailed the State Enterprises Minister, William Duma, noting that the seal needed to be brought in. It was later provided, and the money was paid over in 2 tranches, allegedly under pressure from the minister. AK650 investment was increased by 71,692 times to K46.6 million. When Kummel's board demanded the payment be recovered for portion 406, given a litany of faults in the acquisition, the minister William Duma intervened and on January 25, 2017 instructed Kummel's legal team, Dinen's lawyers, to cease any action against Kirkoram Estates. In the end, Kummel paid a vastly inflated sum for portion 406 on behalf of the PNGi. The armed services were, in effect, forced to buy an inflated block of land. 45.5 million kina that should have gone to the PNGi has instead been pocketed by those standing behind Kirkoram, a fact that should not be lost on any member of the PNGi when their allowances are not paid or their accommodation is in disrepair. These are the essential facts surrounding a land scandal police have claimed is totally above board. Yes, Police Commissioner Gary Baki said, to paraphrase, "Move on, folks, nothing to see here." The administrative inquiry set up to examine the facts under the leadership of John Griffin QC drew the exact opposite conclusion to the RPNGC's high command. While it did not have the power to subpoena records and witnesses, it was able to make one firm conclusion. Criminality was at play. The only question it could not answer with 100% clarity: who are the defendants that should be in the dock? Strap in, as Facts PNG takes you through the Manu Manu inquiry report that the government did not want you to see. They were accused of having engineered a fraudulent land deal to misappropriate a large sum of public monies. Both denied the charges. Prime Minister O'Neill called for a commission of inquiry, but quickly recanted. Instead, he launched an administrative inquiry led by an Australian QC, John Griffin. It could not subpoena witnesses or documents. The inquiry began in March 2017. Griffin QC was told by the Lands Department that the relevant files relating to the properties the subject of the inquiry had disappeared. Griffin QC immediately detected a rat. He remarked, "The administrative inquiry took the view that that fact alone demonstrated that there had been considerable impropriety, which almost certainly included financial inducements to public servants." Let's stop and pause there. Number 1. Considerable impropriety suggests somebody or somebodies were involved in serious illegal activity. Number 2. This almost certainly includes bribery. The inquiry was under no illusions they were investigating crooked land deals. The only question that had to be answered was, who were the protagonists behind these shonky transactions? The administrative inquiry paid close attention to portion 406 in particular. Portion 406 transaction was the one which involved by far the highest amount of compensation, Griffin QC observes. He continues, "It was acquired by way of compulsory acquisition from Kirkoram Estates Ltd., whose sole director and shareholder was one Christopher Polos. Mr. Polos refused to cooperate with the administrative inquiry. The inquiry had no power to compel him to or to investigate Kirkoram's internal records. These were severely limiting features in the investigative capacity of the administrative inquiry," Griffin QC claims. It was almost certainly designed to be this way by the O'Neill government in order to give those named plausible deniability. In so doing, it ensured there would be no fractures in the governing coalition. Despite these limits, the inquiry uncovered some extremely revealing facts about the acquisition of portion 406. Situated 75 kilometers west of Port Moresby, portion 406 is an 847.25 hectare plot of land. On February 25, 2009, the unimproved value of the land was assessed to be 30,000 kina, slightly more than 35 kina per hectare. From 2009 until 2014, the land was owned by M&M Investments proprietary limited. M&M shareholders during this period were George Sariman and Moses Lakai. In 2014, the lease was forfeited by the Lands Department. George Sariman claims his company received no notice, as required under Section 122 of the Land Act 1996. A state lease over portion 406 was then granted to Kirkoram on July 30, 2015. While the land records associated with portion 406 went missing, it was disclosed during the inquiry that the plot was valued at 84,420 kina on July 30th, 2015. This represented 99 kina per hectare. On October 15th, 2015, Dr. Fabian Pock wrote to Mr. Luther Sipaisen, the Secretary for Department of Lands and Physical Planning. The letter states that portion 406 has been identified for the naval base relocation. The department was asked to initiate compulsory acquisition. This was the first occasion in which the administrative inquiry found any record that portion 406 was needed for the relocation exercise. Defense Counsel Decision DCO May 2015, made on February 27, 2015, only mentions portions 422 and 423. This late insertion by the minister turned out to be an extremely fortunate turn of events for the land's new owner, Kirkoram. Griffin QC observes, the basis for the selection of portion 406 is not clear. Its acquisition does not appear to have been endorsed by the Defense Counsel, and there is no information to suggest that its acquisition was ever supported by a feasibility study. Further, at Manu Manu, the defense already had 2,331 hectares available, namely 2023 hectares on portion 154, 138 hectares on portion 422, and 170 hectares on portion 423. Further, portion 406 was well away from the sea. The forfeiture order was gazetted on December 3, 2015. The administrative inquiry observes, Dr. Pock was a member of the Defense Counsel and accordingly must have known that portion 406 had not been approved by the Defense Counsel to be part of the new defense site. In order to compensate Kirkoram, the Value General's Office conducted a valuation of portion 406. The Land Act sections 23 and 24 state when determining land value the subject of compulsory acquisition, consideration is to be given to the current market value only. The valuation cannot speculate on what increase in value the proposed public use may have on the land in the future. A certificate of valuation was issued by the Valuer General over portion 406 on November 3, 2015. Based off an assessment produced by the Assistant Valuer General, Moses Kila, the land was valued at 46.6 million kina. This represented approximate 55,000 kina per hectare. Just 3 months before its value was judged to be 99 kina per hectare. The administrative inquiry concluded the valuation was grossly excessive. It concluded Kila had been bribed or threatened. In support of this conclusion, it noted that the Valuer General did not sign off on the valuation. This is required for any compulsory acquisition over 500,000 kina, Mr. Kila claimed. The reason was that he did the valuation in a hurry. When asked why he was in a hurry, he said he was pressured by officers of the Defense Department. The administrative inquiry also noted that the closest comparable acquisition occurred in 2007. In this instance, the land was valued at between 300 to 350 kina per hectare. The administrative inquiry is not aware of any major alterations in value of agricultural land within driving distance of a major city that would justify the huge difference between the per hectare value determined in that case and that determined in relation to the Manu Manu land. Even if the land, for example, by some stroke of luck in 3 months went from 99 kina to 500 kina, the purchase price will be 423,625 kina, a far cry from 46.6 million kina. While the land was being valued at a vastly inflated rate, discussions were taking place between the Defense Department, PNGi, and Kimmel Consolidated Holdings Limited through its managing director, Gary Hersey, over how to fund the naval base relocation exercise. Kimmel Holdings is the statutory corporation responsible for managing the public's non-mining and petroleum assets. It was agreed Kimmel Holdings would compensate the owners of portion 406 for the land that had been compulsorily acquired. In exchange, the PNGi would arrange for the land at the existing naval base in Fairfax Harbor to be transferred to Kimmel. By letter dated February 26, 2016 from the PNGi to Mr. Hersey, KCH was notified of the compulsory acquisition of portion 406 for the amount of K 46.6 million and was asked to finance the relocation on behalf of PNGi in exchange for title to the Lancre Naval Base, the inquiry observes. The independent committee thought that the evidence strongly suggested that there was a deliberate and calculated attempt on the part of Mr. Hersey and certain senior KCH staff members to not only deceive and mislead the board, including by failure to tender the investment committee report to the board and failing to give full, frank, and material disclosure of relevant facts and circumstances that were within Mr. Hersey's direct knowledge. Instead, information was submitted to the board in a rushed, piecemeal, and selective way that effectively concealed the true nature of the entire Portion 406 transaction and did not disclose the unacceptable risks it posed to KCH's interests. The committee also observed the board was induced to the belief that a state lease for Lancre Naval Base in Port Moresby had been issued and was available for transfer to KCH, which was not the case at all. Set against this alleged backdrop, on October 14th, 2016, Kimmel entered into a memorandum of agreement with Kirkoram to pay 46.6 million kina for Portion 406. Kimmel's manager of legal services, Kerry Tavari, informed the independent committee that this agreement was drafted without any legal due diligence or proper board approval. Revealingly, Tavari claims Mr. Hersey told her to take out the anti-corruption clause in the document. The independent committee concluded that Mr. Hersey embarked on unauthorized and intentional course of conduct to pay the 46.6 million kina to KL. The agreement securing this major windfall for Kirkoram was signed under Kimmel Holdings' common seal. Christopher Polos failed to bring Kirkoram's common seal to the signing. A common seal is an official stamp that signifies the agreement is an act and deed of the company concerned. Gary Hersey, it is claimed, gave immediate instructions for the first tranche of money to be released to Kirkoram even though the agreement had not been properly executed by Kirkoram. That is, there was no company seal. Additionally, the agreement was meant to be signed by the chairman and managing director of Kimmel Holdings, or two directors. It was signed, in fact, by the acting corporate secretary and managing director. The first payment of 20 million kina went through on October 14, 2016. An email from Kimmel's corporate secretary was forwarded by Gary Hersey to William Duma. It stated further to text William, funds gone, but could they come on with the seal tomorrow, please? Are you going to Hagen this weekend perchance? Duma responded, I'm back in Port Moresby now, and will wait for you to return before I leave for Hagen over this weekend. In short, Kimmel Holdings' secretary informed William Duma that the funds had gone through to Kirkoram, and additionally asked for Kirkoram's corporate seal to secure the memorandum of agreement. This is a deal and a company Duma claims no involvement in. According to Kimmel's acting corporate secretary, Jaypal Jairaj, Gary Hersey then instructed him to make the second payment of 26.6 million kina to Kirkoram. Jairaj informed Hersey there was insufficient funds in the company's general business trust account. The administrative inquiry notes, Mr. Hersey then instructed that Mr. Duma had a dividend check from MVL, Motor Vehicle Insurance Limited, is a Kimmel subsidiary, and to send someone to collect and bank the check and have it cleared that same day. Kimmel's corporate secretary later claimed in evidence. Gary Hersey was saying he was under pressure from the minister and wants the payment done at the earliest. He never mentioned the name of the minister. I guess he might be referring to Minister William Duma. Because Gary Hersey kept on calling and mentioning pressure from the minister, I responded in the email to tell the minister the payment could be done next week. On December 23, 2016, authorization of a second payment to Kirkoram was made in the amount of 26.6 million kina. At this stage, Kimmel had not received any form of title over the Lancre Naval Base. But the matter does not end there. The administrative inquiry presents one final detail that is revealing. The independent committee received evidence to the effect that Mr. Hersey issued a direction to relevant personnel for all electronic files relating to the Lancre Naval Base and Portion 406 to be deleted, and for all physical files in the possession of those parties to be handed to him. Some of the electronic files were saved by Ms. Toneo onto an external hard drive. The independent committee considered that suggested a deliberate attempt to destroy and conceal evidence. In light of the numerous flaws in the Portion 406 deal, Kimmel Holdings board issued instructions to recover the 2 payments from Kirkoram Limited. William Duma, in response, summoned Kimmel's corporate secretary, chief financial officer, and board secretary. It is claimed the minister said the board had no authority to engage lawyers on the matter and should withdraw instructions. Minister Duma went so far as to email the legal representatives for Kimmel, Denton's lawyers, on January 25, 2017. The email states, "I do not normally as a minister intervene in routine matters involving the boards and the management of entities I have ministerial responsibilities over, but I am forced to communicate with you directly as a result of a sensationalized article in the PNGi blog yesterday. The management of KCH have in their brief to both myself and the KCH board advised that the transaction in question is in order. As of today, you have no instructions to act on behalf of KCH, the board and the management of KCH. The exonerating brief mentioned in this email was produced, the independent committee claims, with the minister's own personal input. In summary, Kimmel Holdings paid 46.6 million kina for land that was worth in the realms of 100,000 kina. Then news of the scandal hit, courtesy of a post on PNGi blogs. The website implicated William Duma in the Kirkoram sale. Griffin QC observed that there would plainly be a case of corruption against Mr. Duma if it were the case that he controlled the affairs of Kirkoram Estates Ltd. A number of facts are pointed to in the administrative inquiry report, which link William Duma to Kirkoram Estates Limited. For example, during the relevant period, Mr. Duma's home address was the registered office address of Kirkoram and Christopher Polos. In his evidence to the inquiry, Mr. Duma claimed he was not aware until January of this year, 2017, when he met Mr. Polnarau, that his home address had even been registered as the address of the company, Kirkoram Estates Limited. Mr. Duma also told the inquiry that Kirkoram used his postal address as the company's registered postal address, without his knowledge. In short, according to William Duma, Christopher Polos somehow, without his knowledge, discovered the minister's personal P.O. box and address, then conspired to submit false corporate information to the Investment Promotion Authority for no known advantage or reason. Christopher Polos is the second link between Kirkoram and William Duma. A search conducted by PNGi could find no other company Polos is connected to or any public footprint for Polos in the business world. Yet somehow he managed to single-handedly pull off one of the most stunning commercial feats in PNG landed history. The contention considered by the administrative inquiry is that Mr. Polos, in fact, acted as a proxy for a much more prolific individual, the State Enterprises Minister, Mr. William Duma. It is alleged that the sole director and shareholder of Kirkoram is the biological brother of Duma's wife. The inquiry reports, on August 30th, 2017, he was asked whether it was the case that Christopher Polos was the biological brother of his wife. Mr. Duma answered, "Absolutely." He added, "There is nothing wrong with having relatives, and as far as I know, this fellow wanted to develop that land. Everything was above board, even the process of compulsory acquisition." Then in a strange twist, on September 29th, 2017, Duma informed the inquiry, "I have just found out that Christopher Polos, that is why I wanted to, I will be writing to you. I found out after my meeting with you. The last time I appeared before this tribunal, I found out that Christopher Polos is not my wife's younger brother. According to Duma, his wife's youngest brother is in fact K-Boy Polos. Christopher, Duma claims, was adopted by one of my wife's aunties." The inquiry observed, Mr. Duma reaffirmed that he did not know Christopher Polos, who, he said, lives in North Solomons. Yet somehow Polos knew Duma's personal P.O. box and home address, then conspired to misuse it for no known advantage or reason. In short, Duma maintains that an individual he does not know conspired to use his address to register a company, and then somehow obtained a leasehold over land shortly before it increased 555 times in value. After late in the day, it was added to the naval relocation site by the defense minister, Fabian Pak. This same individual's company was then the fortunate recipient of an illicit attempt to vastly inflate the price paid for the land by Kimmel Holdings, a payment that was evidently pushed for by Duma as State Enterprises Minister, and then shielded from civil litigation, again by Duma. Duma maintains these are all coincidences and in no way evidence a conspiracy to misappropriate 45.5 million kina from a state. However, the administrative inquiry added, Mr. Duma agreed that he was asked whether he could find Mr. Polos to bring along the seal for the execution of the Memorandum of Understanding. He said, "That is a matter that Polos and Gary should know. That has got nothing to do with me." Duma, the inquiry, notes denied that there was any conflict of interest on the ground that he was not involved in the decision-making process to pay the money to Kirkoram. This contradicts the evidence reproduced in the inquiry report. Griffin QC, in his concluding statements, noted that he lacked the powers to properly assess who was the owner of Kirkoram. Nevertheless, it is observed in the inquiry report, Mr. Duma's true relationship with the company Kirkoram Estates Limited is a crucial area of investigation because Kirkoram Estates Limited was the entity which, on the face of the documentation, was entitled to the sum of 46.6 million kina compensation by reason of the compulsory acquisition of portion 406, of which it held a state lease. Investigation needs to include investigation as to whether, contrary to the minister's claims, he controlled the affairs of Kirkoram Estates Limited. The administrative inquiry was of the view that there would plainly be a case of corruption against Mr. Duma if, contrary to his denials, he had control over the affairs of KL. Griffin QC further added with respect to Dr. Fabian Pak, who pushed for the compulsory acquisition of portion 406. If he was acting in the interests of another or others, including Kirkoram Estates and himself, his actions, of course, would have been corrupt. The facts of Manu Manu echo on a larger scale a previous land transaction involving the State Enterprises Minister, William Duma, when he was Minister for Petroleum and Energy. This lesser-known deal centers on harborfront land that now forms part of the PNGi Hill estate spearheaded by the Iceland-Australian businessman Gudmundur Fredriksson. On March 27, 2009, the Department of Lands issued a notice to show cause why leases over the land at PNGi Hill should not be forfeited from its then owner NOCO number 96. This notice was posted to NOCO number 96. Before forfeiture was publicly gazetted, a company fully owned by William Duma, Copana Investments, submitted an application to acquire state leases over the subject land on April 27, 2009. Forfeiture of the land was publicly gazetted several months later on September 3, 2009. It is unclear how Duma learnt this land may soon become available for lease. On September 14, 2009, the Minister for Lands exempted the portions from public advertisement. On September 19, 2009, the Land Board recommended the lease be granted to Copana Investments. On November 25, the relevant state's leases were awarded to Copana Investments. The Supreme Court concluded there was an exemption of the land from advertisement and granting of the leases to Copana, a company owned and controlled by a person, Duma, who appears to have been a ministerial colleague of the minister, Temu, in whose name these various decisions were made. When it is considered that this sequence of events occurred in less than 8 months, and that Copana's application for new leases was made well before the leases were forfeited from NOCO, we agree with the primary judge that there would appear to be reasonable grounds for suspicion. At the time this land deal occurred, the PNGi Hill Development Company Limited, the lead corporate vehicle for the PNGi Hill estate, was seeking approval to undertake a major property development on adjacent land. The development master plan showed that the land acquired by Duma in 2009 would be needed for the luxury development. This point was confirmed by a high-level PHDC executive. They state that Copana's land holding at PNGi Hill borders the proposed PNGi Hill estate development. Its incorporation in the project, the senior management team believes, is essential to the proposed 3 billion kina venture. During June 2015, Copana Investments and PHDC allegedly entered into a cooperation agreement. Under the agreement, Copana Investments would release its land holding to the project in return for net equity in the development, once completed. The PHDC executive contends the precise split of equity that will be awarded to Copana Investments for its landed contribution to the property venture will be agreed at a later date, once the development is complete and all liabilities met. If the facts presented by the Supreme Court and the PNGi executive are accurate, it would appear William Duma, through Copana Investments, acquired land forfeited from previous owners. Copana applied for this land before the forfeiture had been publicly gazetted, raising questions over how Duma knew this land was available for acquisition. At the time, it was in proximity to a major property development, which was declared a project of national significance by the government. The land was acquired by Duma's company without a public tender. The lands minister instead exempted it from advertisement before granting the portions to his colleague, William Duma. Because of its proximity to a major development, the value of this land was likely to increase significantly. In this case, without the sleight of hand of a valuer general official. The facts of this case, as the Supreme Court note, raise serious suspicions. They also mimic some of the core features documented in the Manu Manu administrative inquiry. Because the administrative inquiry was unable to establish definitively that Duma was behind Kirkoram, it is impossible yet to suggest there was a pattern here. Were Duma found to be the true beneficial owner of Kirkoram? However, that would certainly be the implication. Kimmel Holdings, it was observed, launched an independent inquiry into the Manu Manu land deal. It focused on the conduct of Mr. Hersey, Kimmel's managing director. According to Griffin QC, the inquiry was informed that Mr. Hersey had been suspended on full pay, following which he had been refused entry to Papua New Guinea. It is not clear if this is a deliberate ploy by the O'Neill government to prevent Hersey from giving evidence on the Manu Manu land deal. Following its investigation, the committee considered that Mr. Hersey had acted willfully and intentionally, and in concert with certain members of KCH Kimmel management, to deliberately mislead the board on a range of critical issues relating to the portion 406 transaction. The payment of K46.6 million to KL at the direction of Mr. Hersey was both grossly irresponsible and improper. The committee also stated that the minister Duma was linked to KL Kirkoram in some way at the time of the relevant transaction, and that Mr. Hersey was well aware of this. As a result, the independent committee concluded that Hersey should be dismissed and any entitlements be frozen while legal action is commenced against the Kimmel managing director. It also asked that the board immediately refer the matter to appropriate law enforcement authorities for further investigation with a view to determining whether criminal charges, including fraud, should be laid against persons involved in the portion 406 transaction, as well as possible prosecution for breaches of the leadership code. Mr. Hersey was eventually suspended and terminated from his position by the NEC. Hersey denies all allegations against him. The administrative inquiry did not submit an opinion on the matter. However, it was observed that owing to the tight time frame permitted for investigation, the independent committee was unable to consider a subsequent written response from Hersey. Therefore, Griffin QC encouraged caution over accepting the independent committee's finding of fact until further investigation is conducted into the allegations against Mr. Hersey. Griffin QC concluded the administrative inquiry, noting, "There are features of the transactions that make it obvious that manipulation and dishonesty were definitely involved. Features such as the fact that the portion 406 purchase was not approved by the Defense Council and that there was no feasibility study supporting it, and that it appears to result in the Defense Department having far more land than it needs at Manu Manu, strongly support the proposition that the compulsory acquisition of land recently granted to Kirkoram Estates Ltd. was contrived. The fact that the valuation was so far in excess of the true value suggests that the valuation was fraudulently high. The fact that the Lands Department files disappeared strongly supports the proposition that there was corruption involved." He adds, "It is to be recalled that, in June 2015, Kirkoram was granted portion 406, paying no more than application fees of 650 kina. Approximately 3 months later, the state commenced the process of compulsorily acquiring the interest and agreed to pay the company 46.6 million kina by way of compensation. Any conclusion that occurred as a result of mere luck strains credulity. Then one goes back to the further fact that a prerequisite to the success of the transaction was apparent pressure on the government exerted by the Defense Department to acquire Portion 406 for the purposes of relocating military and naval installations in circumstances in which there was no qualified opinion to support the appropriateness of the land for that purpose.